The broadcast of the regular meeting of the Police Conduct Oversight Commission Policy and Procedure Subcommittee will now begin.
Good evening. Welcome to the regular meeting of the Police Conduct Oversight Commission Policy and Procedure Subcommittee meeting for October 28, 2021. I'm Abigail Sarah, the chair of the subcommittee, and I'm going to call this meeting to order. As we begin, I will note for the record that this meeting has remote participation by commissioners and city staff as authorized under Minnesota statutes, section 13D.021, due to the declared local public health emergency. The meeting will be recorded and posted to the city's website and YouTube channel as a means of increasing public access and transparency. This meeting is public and subject to the Minnesota open meeting law. At this time, I'll ask the clerk to call roll so we can verify quorum for this meeting.
Commissioner Sylvester.
Here.
Chair Sarah.
Here.
There are 2 members present.
Let the record reflect we have a quorum. Next, we'll proceed to our agenda and minutes from the meeting of September 23rd, 2021. A copy of the agenda has been posted for public access to the city's legislative information management system, which is available at lims.minneapolismn.gov. May I have a motion to adopt the agenda and accept the minutes of the meeting from September 23rd, 2021?
So moved.
Will the clerk please call the roll?
Commissioner Sylvester.
Aye.
Chair Sarah.
Aye.
There are 2 ayes.
That motion carries and the agenda is adopted and the minutes from September 23rd are accepted. Okay, announcement from the chair. Just want to remind the group that this is a special long meeting because we are canceling our November meeting, so there will not be a meeting in November. And now we will move on to the agenda. First, we will turn to one item of unfinished business, which is nuisance misdemeanors. We have been discussing this for several months now, and we have had some additional information which is posted to this agenda, and we have one guest speaker. I'm just going to briefly go over the kind of review what we have so far, and then I will invite our guest speaker to begin his presentation. Okay. We've had several expert community members come to our meeting and provide this group with information over the past months. We've also requested various data sets, and the Minneapolis Police Department did provide us with all of their arrest data from 2018 to 2021. This was a gigantic data set, and it almost blew up LIMS when we tried to upload it to our agenda. So I had to engage a professional to help me kind of analyze this data. And thankfully, Professor Manjit Rege from St. Thomas University, who's the chair of his department there in computer science, was able to take that arrest data and to do his work on it and to analyze it. And he specifically isolated nuisance misdemeanors. And he did prepare a presentation. He wasn't able to join the meeting today. He's teaching class, so that presentation is attached to this agenda for everyone to view. And what he did is he isolated certain nuisance misdemeanors, the ones that we have been discussing over the past several months. And he isolated the data points of race and address in an attempt to sort of capture, if we could, the rate of homelessness around people who are arrested and the race of people who are arrested or cited for these nuisance misdemeanors. And for each one of the nuisance misdemeanors, what we discovered by looking at this data is that there are very significant racial disparities in the people arrested and cited for these kind of low-level offenses. It skews very heavily towards the Black population, although the Black population is just about less than 17% of the total population of the city of Minneapolis. Of the offenses that we were looking at, loiter had the highest racial disparity. It was almost exclusively arrests for Black individuals. And all of the other ones showed a similar level of disparity, also skewing against the Black community. The reason we as a commission, or subcommittee rather, chose to look at nuisance misdemeanors in particular is because there is not the same kind of safety concern or public safety analysis that applies to other types of offenses. You know, it's not assaults, it's not entering someone's home, it's nothing like that. It is public urination, loiter, that kind of thing. And so we've learned of the danger of having this people enter the criminal justice system and start getting exposed to the criminal justice system for this kind of low-level conduct. And we as a subcommittee have been considering other kinds of proposals that we could put forward, other kinds of work we could do, rather than an arrest and a citation. I also included data from Hennepin County for how much it costs to put a person either in the jail or the workhouse. The workhouse is where an individual would go if they were convicted of the misdemeanor. And jail is where they go when they are arrested and pending any sort of trial or plea. And in both cases, it was, I believe, $172 or $192 per night. And that number reflects just the baseline, how much it would cost for an individual to be housed in one of those facilities. It does not include any extra charges for services for individuals who may have a medical complication or require medication or anything like that. One thing we've also discussed on this commission was the incidence of mental illness, people experiencing mental illness or a mental illness crisis when they're arrested for these kinds of offenses. The arrest data simply didn't have a data point for us to track. So I don't have any data to present this evening as to, you know, what percentage of these arrested individuals were experiencing mental illness or a mental health crisis at the time of arrest. Anecdotally, Commissioner Sylvester and I have both noted in our professional experience that often a mental health crisis is something that leads to an arrest for this kind of conduct, like disorderly conduct or, you know, something like that. And finally, on the homelessness piece, the only data point we had to track homelessness was the address of the individual being arrested or cited. So if that address field said no permanent address, homeless, or 1010 Curry, Professor Rege counted that towards his total count of homelessness. However, we all know that that is an undercount because an individual may give, for example, a family member's address where they receive mail, and it looks like that is a permanent address. However, the person being arrested doesn't actually live there and is in fact homeless. That's just one example. So the rates of homelessness, I think, are important for us to consider, and it's also important to keep in mind that these are probably severe undercounts. So that's the data we've gathered to this point. And now I'm very pleased to invite our guest speaker, Mr. Sean Webb, to the floor. He's a supervising attorney at the Hennepin County Public Defender's Office, and he specifically supervises the misdemeanor and gross misdemeanor team. So he agreed to come and speak his professional experience and his team's professional experience, since his team handles this specific kind of offense. So thank you, Mr. Webb, for being here, and please begin any remarks you'd like to share regarding nuisance misdemeanors.
Thank you, Chair Sarah, and thank you for inviting me. I think this is something that is incredibly valuable to be looked at and examined, especially in a time when we're reevaluating what public safety looks like in Minneapolis and Hennepin County, and whether or not resources are being best deployed, or how resources are currently being deployed is the best way to maximize their benefit. In looking at the data that was collected and analyzed by the professor, the racial disparities were stark, and they were pretty consistent with the racial disparities, the percentages that my office, this is something that we began tracking earlier this year so that we would have a better control over knowing how the quality of the race data that we're relying on. And while not identical numbers to the race breakdown that the professor's analysis had, it's very similar. The stark disproportionate representation, particularly of our African American community versus their total population. I think one thing that probably skews our data a little bit is that we're gathering data for the entirety of Hennepin County, not just the city of Minneapolis. Our system doesn't have the ability to separate it out. So in looking at our race data for misdemeanor and gross misdemeanor offenses, approximately 51% of our clients identified as African American, and approximately 27% identified as white or Caucasian. So slightly different numbers, but still grossly disproportionate to the population numbers that we know for Hennepin County and for Minneapolis. Looking at the homeless data and looking at the way that the professor was analyzing that or trying to accumulate that data, I think, well, I don't think, anecdotally, I can say that I think that the percentages that the professor has probably do undercount the homelessness. I think the example that you gave, where people will give a family member's address or perhaps the last address that they were living at, there's a significant amount of stigma for my clients who are homeless. There's a significant amount of shame that involved for people who are experiencing homelessness and housing insecurity. So I think that plays into some of the under reporting. I think there's also a categorization issue about looking at purely homeless as if the person is living on the streets or living at a shelter or not listing any permanent address versus looking at the broader issue of housing insecurity, where I might have a client who's staying with a relative for a few nights, but it's literally 3 or 4 nights, and then they have to figure out where their next move or where their next place is going to be. And so I think in looking at taking out the traffic offenses and looking at the other 6 categories, I think the percentages range from about 10% to 16%. And I think that if we're looking at a little bit broader definition of housing insecurity, we're probably anecdotally, I think my clients are probably closer to 20 to 25% are in that housing insecurity or true homelessness category. Some of the things that I looked at and was thinking about for tonight's presentation was just the impact of an arrest. Setting aside the charge, setting aside the conviction, but just the fact of being arrested, the trauma that causes, the inherent fear that a number of my clients have of any interaction with law enforcement, and when you layer into that interaction, homelessness or substance use disorders or mental health conditions, it ratchets up their fear, and it also ratchets up the threat that the entire situation has the possibility of escalating to. But taking out the worst case scenarios and just looking at your run-of-the-mill, nothing over the top happens arrest, that's still incredibly disruptive for an individual. Their freedom is being taken away from them. They're being handcuffed. They're being put in the back of a squad car. They're being processed into the jail. They're spending anywhere from a few hours to a few days to a few weeks, or in some cases a few months in custody. And so every step of that process just compounds the trauma and compounds the destabilizing effect that has on their life. And when you're talking about an individual who's already in a very unstable position, it doesn't take much to completely knock down any support that they have. And so I think that looking at whether or not, especially these types of offenses, whether or not they're being best addressed with an arrest and a criminal charge. For clients who are experiencing any type of mental health crisis, the stress and the fear can oftentimes be the triggering event. for that mental health crisis or for their mental health condition to go from perhaps a manageable state to a crisis. And for somebody who is dealing with a mental health condition to then have the additional stress of their freedom being taken away and the trauma that that layers on, and then removing them from any of their normal support coping mechanisms. They don't have the ability to communicate freely with their friends or family. If they are fortunate enough to have access to a counselor, that's gone. If they're fortunate enough to have access to medication to help them address their mental health conditions, that's, if not completely gone, it's going to be disrupted for several days while they're waiting for the jail staff to evaluate them, for a doctor or a nurse practitioner to meet with them and to verify that they need the medication that they're requesting. And so it could be anywhere from a few days to a few weeks for them to then get back onto their medication. And then, in the meantime, their mental health has declined, sometimes drastically. I think once we look beyond the arrest and the case going, the person being charged with the crime and the case going forward, there's the stress of having these unresolved cases, these unresolved charges that just weighs on people. I've been representing public defender clients for a long time, and there is just a noticeable weight that this stress of coming to court, the uncertainty of what's going to ultimately happen, how much of a sanction or how much of a punishment are they going to be facing, how much of a risk does each step of the process involve for them. And so you layer that stress on top of all of the other stresses of normal life, and then on top of the stresses of perhaps being homeless or in an unstable housing situation, the stress of having food insecurities, having any number of the stresses that my clients deal with because of their lack of resources. And it just compounds the situation and compounds the toll that it takes on them, both mentally and oftentimes physically. There's a physical price to that, to living in that stress environment for as long as some of my clients end up living. Looking at the offenses in particular that this commission identified, like Chair Sarah said, these are not crimes that are putting the public safety in danger. These are not assaults. These are not driving while intoxicated. These are almost exclusively crimes of poverty, crimes of people who don't have the resources, people who are homeless, people who are struggling with mental health, untreated mental health conditions. So looking at these and treating them with the same response that we would treat a allegation of domestic assault, it's a disproportionate response to the actual societal impact. Looking at the homeless data, again, taking out the traffic offenses, and even using just the smaller numbers that the professor identified, I mean, we're looking at 10 to 15% of these citations being issued to people who are homeless. And so if you think about urinating in public, consuming in public, possession of drug paraphernalia or loitering, all of those are intricately involved in somebody not having a house or a home to go to. I mean, nobody wants to be in a situation where they're having to urinate on the street. I don't care who you are. And so, you look at these things that over time society has criminalized, and you look at them through the lens of homelessness, and you really start to appreciate how these are not people who are choosing to commit these offenses because they want to offend somebody's sensibility, they want to break the law. These are people who are committing these offenses because they have no other choice. They don't have the same options that those of us that have more resources would have. And so, I mean, you look at pretty much everything other than the driving offenses and the disorderly conducts, and it's really hard to argue that the other five are not intricately intertwined with the person's resources and are not intricately intertwined with the homelessness and the housing insecurity that so many are struggling with, and that unfortunately only been made more severe the last 18, 20 months of the pandemic. I'm just looking over my notes to see if there's anything. You know, the effectiveness of criminalizing this behavior is really negligible. I mean, if we look at you know, criminalizing behavior to deter it or to make people stop doing it, this type of behavior, because so much of it is not, you know, crimes of choice, it's crimes of desperation, or it's behavior that's brought about because the person has no other options. You know, arresting this person, charging this person, prosecuting this person, and potentially jailing this person, it doesn't, when they're done with the system, when they're done with going to court, when they're done with serving jail time, if that happens, they're still in the same position where they don't have the resources to not make these choices. And it would seem like, and personally, my experience is that when we address that underlying issue, when we address the lack of resources, when we address the housing insecurity, when we address the mental illness, the behavior that's being criminalized goes away to a much larger extent than it does when we prosecute those offenses, when we try to incarcerate this behavior away. So I think as people are starting, or as people continue to think about how do we address public safety, I think part of the conversation needs to continue to expand around, how do we ultimately achieve the goal? If the goal is to limit or to decrease behavior that society finds objectionable, are we actually doing that by charging people with crimes and prosecuting them? Or are we simply perpetuating the circumstances, and in some cases exacerbating the circumstances that's causing that behavior that society finds objectionable? Whereas if we were making more resources available to those people, getting them in a more stable situation, then a lot of these behaviors would go away, because these are not behaviors that they're doing because they necessarily want to. It comes back to they're doing them because they don't have any other options. And we've seen, particularly with the city of Minneapolis, after people have been charged with these cases, have been brought into court, are being represented by my office. The pandemic screws up my perception of time. It's now been almost 3 years that we've had restorative court, where Hennepin County social workers are working with my office's clients to access resources. And we've been tracking the recidivism rate from the participants of restorative court. And recidivism rate is the percentage of those people who come in and engage with their social worker, get access to resources, and then then charge with a new crime at some point down the road. And when we're talking about a unstable population like our homeless population, for these types of nuisance offenses, historically there's been a high recidivism rate, because again they haven't been given the stability to not be in the same desperate situations. But with what we found, or what we've seen with the introduction of actually helping them, providing them access to resources, helping clients find stable housing, helping clients get access to mental health treatment, get access to chemical health treatment, working on employment opportunities, is that this, what had historically been a high amount of repeat offenders, repeat chargers, has dropped drastically, where the recidivism rates dropped by over 70% for the people who've engaged and worked with the social workers. So I think we have shown through that very small microcosm that if you provide resources to that population, that the behavior that society finds objectionable in large part goes away, because it's not that they're going out with the volition to commit this behavior, and it's because it's oftentimes being driven out of desperation or lack of other options. And when they have the resources to have other options, surprisingly, the behavior stops.
Thank you so much, Mr. Webb. I'm going to open up conversation to the subcommittee, which includes me and Commissioner Sylvester. Commissioner Sylvester, did you have any remarks or questions for the speaker?
First of all, thank you so much for coming tonight and for sticking around. I imagine maybe a little later to hang out with us tonight. We talk about the African American population in the city of Minneapolis being between 15 and 17%. Google is telling me the African American population of Hennepin County is about 9%. So, I mean, your statistics, if we're talking about 51% of the folks that you're dealing with are African American in your misdemeanor system, and the percentage is half, that tells me that the problem in Minneapolis is probably even more stark. You know what I mean?
Yeah.
Second of all, I'm really moved by what you said about the idea of disrupting somebody's life and how disruptive it is. I work as a paramedic for HCMC, and so I run into a lot of these folks, and I run into a lot of the folks that the cops don't necessarily want to bring to jail, right? And I've grown deeply thankful from my time on this commission. I've learned so much about this idea of misdemeanors and what that disruption looks like in life. I've grown very thankful of those officers who choose to just get me involved, right? Versus taking somebody to jail. Because a couple hours in the ER or something like that, you know, is one thing, but it's not, hopefully not as disruptive. A couple of years ago, I was charged at the end of my shift about 8 p.m. at HCMC with going down and refilling a small little box of medications that we use. And I went down to the basement pharmacy in my old brown uniform that we used to wear. And the pharmacist pointed to a countertop and said, "Hey, your meds are over there." And there were 4 large paper bags, like grocery bags, filled with medications. And I was like, I just need this little thing of Versed here. And she goes, "Oh, you're not from the jail?" And it was like 4 shopping bags, and it was for like the next 5 days, like just a tremendous amount of medications, you know, mixed together, whatever. And it just blew my mind how many medications are really running through a place like that at any given time. The last thing I just really want to recognize you for is that idea of weight of these pending cases, right? Like, I don't think as a society we give enough thought necessarily as a society to that idea of what that stress does to somebody physically and mentally, especially if somebody has, let's say, chronic diabetes, chronic hypertension, any other, you know, kind of manageable condition in any other setting, right? That psychological weight and how that affects somebody's physical and mental health is just a really powerful statement. So I appreciate that today.
Thank you. And Mr. Webb, I just want to clarify, I've been talking to a lot of community members about this, and people who aren't in the criminal justice system or aren't paramedics, they are surprised that a person can be arrested and taken to jail for this kind of offense. So if I could just verify with you that when they're arrested, they are in jail, and you visit your clients in jail. I mean, this is.
So all of the offenses that are looked at that we've been talking about tonight are misdemeanor offenses. And so they do carry a possible penalty of up to 90 days in jail. And if somebody is charged with one of those offenses, the officer does have some discretion about, they don't necessarily have to arrest the person. They could issue a citation, give them a summons for a future court date, out of custody. But they can also choose to arrest them and have them brought into the jail. They're booked in. They're usually held overnight. If they're arrested on the weekend, they might be held for several nights before they have the opportunity to meet with one of the attorneys from my office and appear before a judge, where thankfully most often they are released. And certainly on these types of offenses, they are almost now at this point almost always released. But even if we're talking about 24 hours in jail for a crime that's really, behavior of desperation and homelessness, and the trauma that 24 hours has now inflicted on that person, and just the wrecking ball that is to any stability that they had been able to build is just now almost always flattened. And so while it's not every time that they're going to be arrested and brought to jail, for these offenses, it seems like any time that somebody is arrested and experiences that type of trauma, where we're talking about behavior that really is not putting public safety at risk, it seems unnecessary. And seeing so many clients that have been so destabilized by that over and over again, it seems that more than anything is actually perpetuating the behavior, because it perpetuates the instability, it perpetuates the trauma, instead of doing what it's designed to do, which is eliminate or minimize the behavior.
Mr. Webb. If there's nothing else from Commissioner Sylvester, I will open this up for public comment. Good. Okay, I will now open the discussion for public comment. If you could please press *6 to unmute yourself. *6 to unmute yourself. Would anyone like to make comment or address the speaker or the commission this evening? Thought I heard something. *6 to unmute yourself. Okay. Yes, Commissioner.
I'll say one more thing. This has me thinking about driver's licenses and how important that sort of ID card is. And I think in order to rent an apartment, I would have to have an ID. In order to get an ID, if I lose that, I would have to go to the Social Security office and get a copy or a new Social Security card, right? It seems pretty benign. It sounds like something I could take probably in an afternoon, right? Pre-COVID. But with COVID, I have to go to the library. If I was unsheltered or experiencing homelessness, I would have to go to the library. I would have to use that computer to sign up for a time at the Social Security office. I would have to go to that office, wait in line, get that Social Security card, and then set up a time with the DMV and have to walk to that DMV on my appointment date in order to get that license. And if you disrupted that schedule by going to jail, you wouldn't be able to access any of that service. And that's such a delicate balance, even for me with a working vehicle and working internet in my pocket. That has to be such a delicate balance for somebody. Just so deeply disruptive anyway.
And to that point, almost always the first thing that when my clients are working with one of the social workers, the first thing that the social worker works on with them is getting that ID, because that is such an integral part of transacting in our society, and something that so many of us take for granted. It's something that so many of us don't have to really think about once every 4 years, once every 5 years when we have to renew our license or renew our ID card. But like Commissioner Sylvester said, there is such a delicate balance between going through all the steps and completing them all in the right order, in the right time, at the prescribed appointment. And again, for individuals who have resources and means, it's an inconvenience, but it's an afternoon. Whereas, for a person who's homeless, it's not insurmountable, but it is a much more difficult task and a much higher hurdle to clear.
I can't get a cell phone without an ID, other than maybe like a track phone. Like I can't get a cell phone without an ID. I can't get a bank account for any sort of public service to be direct deposited into. And so now I'm paying 15% to the unbank, right, to cash my check, which is easily losable, versus having it direct deposited in a bank. You're absolutely right. That step is so critical.
And Mr. Webb, you brought up a good point. I got numbers for how much it costs to put a person in jail, but I actually didn't account for the cost of a court proceeding, to fees for the city attorney's office, the judge, the deputies in the courtroom. All of that is very expensive as well. Even if they ended up pleading guilty and not having a jury trial, and if they have a jury trial, that number is increased. So there are a lot of costs associated with this. And one thing we're considering as a commission is if there isn't a benefit, like if the behavior is ongoing, if it doesn't intervene in that behavior, if it doesn't make our society any better, then this is quite a high cost to pay as taxpayers, to say nothing of the toll it takes on the individuals. So thank you. Okay. Anything else, Commissioner Sylvester? Otherwise, I will let our speaker get back to his life. Thank you so much, Mr. Webb. This is really valuable input, and we really appreciate your time.
My pleasure. Thank you for having me tonight.
Thank you so much.
Okay, next item, unfinished business, arbitration. The next order of business on our agenda is discussion of arbitration decisions, which is continued from our September meeting. I will now open the floor to discussion with my fellow commissioner, and I'll call on myself, and I will say, I've been working with the city attorney's office. Mr. Fussy has been very helpful trying to get these opinions to me. So far, we only requested the 10 decisions where the city lost in arbitration, because if they won, they won. They did a good job. So far, I've received 7 out of 10. So I don't have a complete data set, but we've put this off so long, I wanted to at least discuss it with the group or with the subcommittee before we bring it up to the full commission. And I did provide as much data as I have and the decisions that I have. And, opening up discussion with you, Commissioner Sylvester, what I observed is that, first of all, in 16 years, there's been 26 arbitrations, and the city's won most of them. The city won 16 out of 26. And in the 10 that they lost, 9 out of the 10, discipline was imposed. So there was still, they might have lost count 1, but count 2 was upheld, or it might have been sustained, but the discipline was lowered. So there was still, the city still partially won or had a discipline for all except one opinion or one arbitration in 16 years. And I actually a community member emailed me the arbitration decision for that one, which I haven't shared because it's not public data, but just sharing that the date for that one is 2010. So we actually haven't lost, just outright lost with no discipline, nothing, an arbitration in 11 years. Just sharing with you my experience as an attorney in court, that's a pretty good win record. I mean, if arbitration fell off the face of the planet and all of a sudden everything was in district court, that's a pretty stunning win record. Another observation from reading the opinions, which were pretty heavily redacted, but I was able to kind of glean what happened. Most of the time we lost because a piece of the investigation was missing. You know, they didn't interview the key witness, or they didn't interview people who were on the scene, something like that. Disparate impact, where this officer was being disciplined in this way, but other officers had not been disciplined for the same conduct, or not disciplined as severely for the same conduct. In one instance, the officer was actually being bullied by his supervisor and the administration. And basically comes down to HR, that they didn't follow the rules of progressive discipline, they didn't do a thorough investigation, you know, that kind of thing. So those were some of my observations. Opening up the conversation to you, Commissioner Sylvester, did you have any observations or questions you'd like to?
That was my observation, that how many of these cases did involve like what I understand to be kind of past practice, where in the past we discipline officers this way, and now this guy, you know, got this discipline or something like that. That's what jumped out at me.
I'm going to go ahead and open this up to public comment. If anyone would like to ask a question, provide information, address the commission, please press *6 to unmute yourself. *6 to unmute. Any public comment?
Hello, this is Dave Becking. Yes, I'm very glad you're discussing this. I'm still upset that you received such a, incomplete record of these arbitrations, and that the ones you have are redacted to the point of being almost unintelligible in some cases. There's a lot more information there that is actually quite helpful to understanding what happens in the arbitration. Based on that, I finally, and I apologize for it being so late, finally sent Chair Sarah 14 arbitrations that I could find in the last 20 years with the Minneapolis Police Department. And so those have no redactions whatsoever and are public documents, with possibly one exception that I think is the one you mentioned already. And that is going to make it a lot easier to take a look at this, plus give you twice as many cases. And I'll be sending some more, because I still am finding some more on the Bureau of Mediation website. In any case, yes, this is interesting. I think it's very important. In Communities United Against Police Brutality, I've worked on this particularly, but we've discussed this and even put a flyer, which is on the front page of our website, regarding our feelings about arbitration. And the use of arbitration as an excuse of why we can't discipline is really not valid. And those who are recommending that we somehow modify the grievance or arbitration proceeding, particularly to get rid of arbitration, I think have got it wrong. The problems with arbitration lie not so much in the process, which is I think a very important due process protection for police officers, not all of whom deserve the discipline that's recommended by the department. There are occasionally times when it goes the other way. And it would be a slippery slope for any other public employees to do that. Instead, the department has got to get its act together to consistently win, because though it only lost outright in one of these 26, they're saying, some of the reductions in discipline were very substantial, from a termination to 30 hours. Because of the reductions in the ones you're seeing, you aren't able to see what the original recommendation was. So sometimes it's pretty easy to read between the lines and figure that out, or you might even know something about the case. But those are very substantial. And as far as the police department and its credibility is concerned, both with the public and with its own officers, not being able to make a firing stick and just wind up with 30 hours suspension is a very serious loss. And there's been cases where officers have had that kind of reduction in discipline, and it's led to the further incidents in one or two cases that have led to termination later on. So something that should have happened earlier. So those cases are very important. And yeah, I'm going to try, as I said to Commissioner Sarah in my email, I'm going to try to set up a spreadsheet to kind of look at these better and see what some of the patterns are, and get this all documented in one place and in a way that's much easier to understand than, you know, a few heavily redacted arbitrations coming in every month. So I'm sorry I haven't done that earlier, and you have another no November meeting, so I will have, I hope, a lot for you in December so that you can evaluate this, because it is a very, very important issue. It's an issue that comes up in public very frequently, and I think a better understanding will help tremendously in making the kind of recommendations that are needed, and the kind of recommendations that CUAPB has made to the police chief since we first met with him over 4 years ago. Thank you.
Thank you, Mr. Bicking. And that reminds me, my actual announcement, which I forgot to give, was that so the city provided me these heavily redacted opinions. Several of them, I found several, and it sounds like Mr. Bicking even has more, are available on the public website, the Minnesota Bureau of Mediation Services. The website is mn.gov/BMS/, and you can look up arbitration decisions. I spoke to Mr. Fussy about that, and basically the city attorney's office takes a more conservative view of data practices than, I don't know, than the Bureau of Mediation Services, so that's why it's so heavily redacted. That's kind of its own separate issue, but since I'm sitting on this commission, I didn't feel comfortable. Mr. Fussy didn't recommend disclosing this unredacted since that's the city's position, but it's acceptable for me to make this announcement and say that there are these other unredacted opinions. I think it'd be valuable to see the unredacted versions. I think that something is lost with the rejections. Is there any other public comment?
A lot is lost, yes.
Yes. Thank you, Mr. Bicking. Any other public comment on this point? Then I would like to propose to Commissioner Sylvester that we actually bring this back to the full commission. I think this probably merits a research and study within our audit subcommittee. And I think that research and study could happen much quicker than some of the other research and studies, since it is a data set of 10 cases, you know. And perhaps if it was just the audit subcommittee, perhaps there is a way that they could review that data, including the one instance where there was no discipline. Even though it's private data, if there's a way they could review it so that they could just have the full knowledge of what happened and make any kind of recommendations of how to improve the arbitration process moving forward. That was my thinking. I'd like to hear your thoughts.
I agree. I think we've had this as a subcommittee for long enough. I think we've fleshed it out long enough. I think we've done some pretty good work. I think you've done some pretty good work gathering this all together in one place. Yeah.
Okay, then I will, as chair, put this on the agenda for the full commission to consider. And thanks, Mr. Bicking in particular, for engaging and bringing this to our attention in the first place in your presentation that you gave a few months ago. We appreciate that engagement. Thank you. Okay, now I believe I've lost my script. Okay. Our next item of discussion is the issue of discipline. I will now open the floor to discussion with my fellow commissioner. I did provide some supporting documents for this issue of discipline. This is something that was actually discussed with the full commission back in 2020 before you were appointed, Commissioner Sylvester. And it's adjacent but not the same as the issue of coaching, and that was sort of how the context came to us. In 2020, the MPD manual said that discipline was mandatory. All sustained incidents of misconduct shall result in discipline. That word sustained is important because it meant that there was an investigation and there was misconduct found. So we aren't talking about, you know, the salacious complaints or the totally erroneous complaints. We're talking about things that were investigated and confirmed. And in 2020, it was also required to do discipline according to the civil service rules. And I did include the civil service rule that applies, which is Rule 11, which is discipline, which ranges from a warning up to termination. And just a point of clarification, I was talking to a community member about this. Under the civil service rules, that warning, a formal warning where you know, sit down and you have a warning in your file, that is discipline under these rules. I suppose there could be an informal warning or something of that nature, but that's what I'm referring to with that. Then on December 31st, 2020, the mayor and the chief made a change to the discipline policy. They erased the section 5-1002 that said discipline shall be issued, and they made discipline optional, and said that the chief may issue discipline. A person would be subject to discipline, and then talked about for sustained acts of misconduct, discipline, if any, is imparted by the chief.
Police Oversight Commission.
So I wanted to bring up this policy change, and I wanted to bring it up right after arbitration, because my observation from reading these arbitration decisions is that we tended to lose in arbitration or do poorly when there was too much back and forth. There was too much discrepancy in how discipline. I think someone might be unmuted who should perhaps be muted. So if folks could check. Anyhow, since the problem in the greatest problem in arbitration seems to be discrepancies in discipline, it seems to me a bad policy idea to make discipline optional. It seems like that opens the door to problems with arbitration, or even just, you know, upholding discipline in the future, because it seems like it would open the door for the chief issuing discipline in this case, but not this case. And it would open up the, you know, the argument for the union or whomever to say, well, you disciplined me, but you didn't discipline this cop. That's not fair. It's disparate impact. And then, you know, we're kind of back to square one. So I did want to have this discussion, you know, right next to arbitration. Those are some of my observations. Oh, and my final observation, I wanted to share Derek Chauvin as one example. He had a series of very serious misconduct, including egregious excessive force, where he was not disciplined. And this all came out in his criminal trial. The Attorney General filed a list of all of his excessive force incidents and misconduct. And in fact, one of those incidents of excessive force is now a federal crime. He's being charged by the Department of Justice for a federal crime. And for that particular instance, he was not disciplined at all. So I think in real time, we are experiencing as a city the absolute worst case scenario, the absolute nightmare scenario of what happens when discipline is not used to intervene and stop misconduct. And that's the example I wanted to give. So excuse me for being long-winded. Commissioner Sylvester, did you have anything to share with the commission?
Yeah, reading this stuff, it makes me think about discipline, like where this type of discipline starts, right? And it feels like it starts maybe, like reading these cases, it feels like it starts in the precinct level, right? Like with sergeants and the precinct inspector and stuff like that, before it ever, you know, really graduates to the level of like maybe internal affairs of the chief or something like that, right? And it's one thing to give the chief this type of power, but I worry that maybe we're giving these we're giving precinct level supervisors just a lot of leeway to discipline folks that they work with day in and day out, right? If we only have 500 some officers right now, and we should be looking at over 800 officers right now, right? You need everybody to show up to work. You need everybody to work extra hard. And Yeah, Frank over here, he's been having a hard time the last 18 months. We're just going to cut him a little bit of a break here. He's been under a lot of stress, whatever. A lot of this just screams to me like are we looking are we looking at precinct level leadership? And I'm not trying to condemn anybody. I'm just saying like I'm a lot of this is focused on very high level NPD stuff, and I'm just curious where that kind of precinct level leadership falls and where the decisions come from.
That's a really good point. And in fact, in one of the arbitration decisions, was older, but it did say that the internal affairs officer, it wasn't the chief, it was, like a precinct level internal affairs investigation. And that person had been a cop for many years, but didn't receive any internal affairs training. It was old, so that could have changed. So that brought up a question to me is what kind of training is there for like internal affairs type investigations? And is it only for like the chief and the commander, or does it trickle down to the precincts? So I'm with you on that.
Yeah, and reading through these, there's a lot of really egregious behavior in some of these cases, like pretty egregious behavior. But there's also, and one that comes to mind is the gentleman that they found at the gay 90s, and it was fascinating. I think maybe it was one of the first cases that was on the list. They saw this guy at the gay 90s. He was yelling and screaming. He had blood on his face, right? And they did some, in my opinion, some pretty good police work. Hey man, here's your sunglasses, here's your hat, here's your coat, man. Get out of here, walk that way so you're not going to be a problem with anybody. Go have a good night. Go get a cab, go home, whatever. Go sleep it off, right? And if that happens, if he goes somewhere and sleeps it off, like none of this takes place. He doesn't get punched in the face, like none of this happens, right? So you've got really good police work. And then you got a guy that's, ends up like puts himself in a situation, right? Continues to be intoxicated and kicks a couple of cops, and gets some haymakers in the face. Like that's, I clearly see where maybe there's a violation of policy here with these guys, right? But I also recognize that like in this case, this is not clear cut where it's like cop got out of his car, smoked a guy in the face, right? No, there was a long, you know what I mean? Like there was good police work here. There was some questionable police work here. And then there was some really violent police work here. It just brings to mind to me how dynamic these cases are, in some ways.
Certainly very dynamic. And I think, it's opinion, but, in my opinion, I think that's why some form of grievance, arbitration, whatever, I think that is really important. Because, I think Mr. Bicking said it, that's an important right for the police officers who are either totally falsely accused, or there's, mitigating circumstances. So I guess my inclination would not be to recommend getting rid of arbitration altogether, and it's state law anyhow. I mean, it's just out of our hands. I think it would be to tighten up the discipline process, maybe to use the lower level issues more often, like the lower level discipline options more often, such as a warning or a reprimand. So there's at least a record, and you can sort of document the case, and also try to intervene. If an officer is having a problem, try to intervene at the beginning of the problem. Like if they need to change shifts, let them change shifts. If they need, I don't know, PTSD support, let them have, let's do an intervention, and let's not wait till it's absolute crisis. That doesn't serve anyone.
I agree, and I think the sheriff's department is doing some really interesting work on this, from what I've read, about mental health support with officers and early intervention and stuff like that. So those things exist, and that might be a really interesting place, for the commission to go next year to look at best practices when it comes to early intervention. The Polad Foundation just gave the city a bunch of money to kind of work on this idea of intervention, but what sort of early intervention programs are working, where are they working, that sort of thing.
I think the danger is if there's no discipline, then there isn't a record, and the officer doesn't get the intervention and doesn't really get the message that this is a problem. And what could be a low-level one-time thing, we're opening the door for it to escalate.
Mhm. Which is why, and which is why to me, coaching is probably really, could probably be really dangerous in this, right? Because it feels, from a managerial perspective, it probably feels like you did something, right? Like you feel like you took action, but you didn't hurt somebody's career. You didn't hurt their pension, possibility. Like you didn't, you know what I mean? Like you did something, but nothing really came of it, and you didn't, this guy isn't going to stop showing up to work. You know what I mean? Like, I can see from a managerial standpoint, especially in their staffing crisis right now, how coaching could be really attractive. Like, hey, I talked to Steve out in the garage, and he's going to knock it off from now on.
Right.
You know what I mean? But now there's no record, right? And like we don't have that sort of early intervention. Mm-hmm.
And when you may remember this, Commissioner Sylvester, I think it was May, and we had city leaders come to speak to us about coaching. And when they described coaching in the process, it was exactly word for word what a warning is under the civil service rules. And so I think what's happening is that instead of issuing the warning, which would be a record, like you don't lose your job, you don't get suspended, but it's a record. They're doing the coaching, and so there's no record. And that just keeps happening over and over again, and it's snowballing. It's nothing happening with that.
It is, and it makes me think about it makes me think about, and maybe this is me just being paranoid, but it makes me think about lawsuits, and it makes me think about like what happens if we are so hyper focused on preventing lawsuits that we're actively not creating paper trails for this type of stuff. I don't know. I don't know.
I agree with that, and I think that's an instance of playing the short game and not the long game, where you're trying to avoid a lawsuit. But then, I can tell you this as a litigator, when the lawsuit does happen, your exposure is that much greater. Because then when the lawsuit does happen and they go through discovery and there were these complaints and there were these, all this stuff that happened, then the city's actually on the hook for a much, much higher dollar amount that they knew the officer had a problem. They had an opportunity to correct it and they didn't correct it. It actually is worse for us in litigation. So in order to play the long game and really think about what position we want to be in litigation, I think the answer is going back to mandatory discipline under the civil service rules and having a paper trail. And I don't want to even think of this in terms of litigation. I mean, that sounds sort of disrespectful to the people who are being harmed by this. I think we also need to have some truth and reconciliation within the city and say, this is a problem.
Mm-hmm.
And how are we going to address the problem? And right now we aren't taking that responsibility and we aren't addressing it. I'm still getting answers from the city attorney that we can't talk about coaching because there's litigation. That's still the position we're in.
Mm-hmm.
And we are under investigation, the city is, by the Minnesota Department of Human Rights and the Department of Justice. And assuming that they would find racial disparities or anything like that, assuming that they enter into some sort of consent decree around that, I think the city would be in a much better position if they can say, we took responsibility for our problems before the dissent decree, before you made findings, and these are the remedial actions that we have voluntarily started. If the city would start addressing this right now and owning it right now, I think that will reduce our exposure in the future with the MDHR and the DOJ.
Okay.
Is there any public comment? You and I just sort of have this little dialogue going over deep. Would anyone from the public wish to address either of us or both of us? Please press *6 to unmute yourself if so. *6 to unmute
This is
yourself.
Dave Bicken again. Yes, this discussion of discipline is very important. I'm glad you're having that, and I'm very glad you found and pointed out the change in the policy manual. This seems to have been prompted by the policy manual at one time was written in the sense that coaching was discipline, and thus, such a provision was appropriate that, all misconduct will result in discipline, or words to that effect. And I suspect, though I guess we can't know, that the change was made in order to reinforce the position that coaching is not discipline, now that people want to see the results of coaching, and they want to keep them hidden because it isn't discipline. So very important, and I really appreciate your bringing that up. That's something else to say, but at this point, that's all I can think of right now. Thank you.
Thank you, Mr. Bicken. Anyone else, please press *6 to unmute yourself. Okay, I'm not hearing any comment, and Commissioner Sylvester, I feel that you and I have had a very fruitful discussion. So I think I'd say the same thing I said about arbitration. If you agree, Commissioner Sylvester, I'd like to bring this back to the full commission.
Yes, I agree. That's a great idea.
And I think it should be considered by the commission sort of adjacent to arbitration and adjacent to the coaching study. I think they're all intertwined.
I agree. Mm-hmm.
Okay, then I will add that to the agenda for November.
Great.
All right. Thanks to all who made public comment this evening. I will direct the clerk to receive and file these comments. With that, we've concluded all items on our agenda for this meeting. Just a reminder, we will not be meeting in November. Seeing
May
no
I
further
make a
business.
comment under the general public comment, item 7?
Yes, beg your pardon.
Yeah, that's all right. It's all right. I just wanted to say quickly, I really look forward to a couple of months from now when this committee and the full commission is at full strength. That'll be a big help. I appreciate your continuing on and in the rather unusual circumstances of a two-person committee, but the amount of work you're doing and the importance of it certainly warrants your continuation, and I think you've done a good job of it. The one other thing I wanted to say is that you have gotten a lot of data together here, and particularly that huge data set regarding the nuisance things and the complaints and the racial disparities in those. I hope very much, or if you are, I hope that you plan to submit those to both the Minnesota Department of Human Rights and to the Department of Justice as parts of their investigations. This is important stuff, and it's the data that they kind of like to have. And I understand they are also very good at crunching large amounts of data. So both the data and your discussions of it and thoughts about it, I think would be greatly appreciated by both organizations and by all of us who feel that it's important that the work that they're doing as well. So I just want to make sure that that happens on behalf of the PCOC. Thank you much. Goodbye.
Mr. Bicken. I did submit the professor's analysis to the DOJ and the Department of Human Rights.
Good. But
And-
they like
and
to
the
get
full
the
data set.
underlying database. Oh, good. Excellent. Thank you.
Does anyone else have a general public comment? I apologize for skipping the general public comment. Please press *6 to unmute yourself. And it looks like someone just called in. I admit you.
I did. I love doing that.
I'm trying to. Okay, I believe someone just joined the call, and it is now general public comment. If anyone would like to make a public comment, please press *6 to unmute yourself. *6. perhaps it was a wrong number. Hearing no thanks to all who made general public comment, I will direct the clerk to receive and file these general public comments. With that, we've concluded all items on our agenda for this meeting. Seeing no further business to come before us and without objection, I will declare this meeting adjourned. Thank you.
Thank you.
Thank you.